If you go back many years, though, basically to the introduction of the Division 7A regime in the late 1990s, early 2000s, one of the anti-avoidance provisions that they brought in was ultimately called Subdivision EA. And that said, regardless of any other provisions, if you've made the distribution and you've left a UPE and you create a debit loan out to individuals, well, then that debit loan has to comply with the Division 7A rules. And we have lost count of the number of case study examples where EA has been simply looked over. Often what they will argue is that, oh, well, as long as we've lent that out for income generating purposes, so to help in the business or whatever else it might be, as long as we haven't gone and used it on a new boat or a fancy holiday, as long as the debt is deductible, then it's okay. And the reality is that it's not okay, and it's actually a huge tax problem. And in this particular scenario, we're linking back into a divorce. We had two problems. Firstly, we identified that there was this EA problem, that they'd make the debit loans out, and there was a big tax issue sitting there because no one had ever been paying any interest. Interestingly, though, in addition to those loans, which were fine, there had been purported distributions down to the wife over many, many years. However, the wife was not a beneficiary. So not only did we have a big EA problem, but we also had a whole raft of distributions over many years that were completely invalid on the face of the trust instrument. And so the parties had to enter into a settlement where the husband basically took over control of the trust. The wife got paid out all of her loan accounts and was entitled to keep all of her historical distributions, and they settled on that basis. Now, the really interesting thing, and what we can't claim a lot of credit for all the time, but now looking back, it's an absolute no-brainer and it's on our checklists for these settlements, is this. Sorry, read back. There's red on the backboard. Read back. The wife and her family lawyers asked for a tax indemnity in relation to both the failure to comply over the years in relation to EA and the inability to read the deed. So in other words, to have made all of these invalid distributions. Case settled. Never went through the courts as such. They settled on the papers. The consent orders went through. Indemnity was in there. 3 months after the wife had been paid out, husband gets a tax audit. Now, it might be that that was just a complete coincidence, but the wife didn't have to worry about it because she was fully indemnified. The husband, on two levels, had a huge tax problem, quite aside from the payouts that he had to make under the family law settlement.